Some of the biggest risks for signing a contract without reviewing it, especially with an attorney, is that you might rush into agreeing to something that you don't fully understand or something that you didn't intend to agree to in the first place. There's a lot of important language in a contract, and it's important to go through and make sure that first, all that important language is there, and then second, that you understand what it means and that you understand the implications of what that language means. People are always very concerned about who's getting paid, how they're getting paid, how much they're getting paid, when they're getting paid. And those are very important terms, but they're not always the most important terms. Some other things that come up frequently when I'm working with clients is, how do I get out of a contract, or maybe how do your clients get out of the contract? So it's important to make sure that you understand termination language. A good example that kind of highlights that is, think about a gym membership. I think that's something that many of us can relate to. A lot of times, gym memberships require you to give 30 days notice to terminate your gym membership. And many people think, hey, I can just show up and say, hey, I want to cancel this, I don't want to pay next month, and have it canceled. But that is not the case. With a gym membership, maybe not as big of a deal. You might be out $100, $150. But for a major business contract, you could be on the hook for thousands of dollars in services that you don't really want anymore, but can't get out of. Because a business owner's personal interests and the business interests are so closely intertwined, making a mistake or not understanding your contract could really have big implications for your business and for yourself personally. As a new business owner, when you're signing a commercial lease, frequently landlords, they don't necessarily trust your business yet. You haven't proved that you can make a profitable business and continue to pay the rent at this commercial space. Commercial landlords will often ask new business owners, and in some cases established business owners as well, to sign a personal guarantee, basically saying, hey, look, if the business isn't able to pay or defaults in some other way, then the business owner or business owners will be personally liable to pay for the rent. And this is just a great example of when a business contract can put your personal assets on the line, even though you are entering into the contract through your business. There's a lot of important language in contracts, and a lot of times business owners are only concerned with the very basics of who's entering into the contract. I'm entering into a contract with this business to do these services, and I'm paying them this much, or they're paying me this much. But there's a whole slew of language that really ends up being more important in the long term. Things that might come up throughout the contract. If it's a commercial lease, who's responsible for repairing the space? If it's for services and somebody gets injured, who's responsible for taking care of the person who's injured? Who is shouldering the liability under a contract? Other things might include the jurisdiction where disputes can be decided if you end up going to court. Especially if you're contracting with a business that's out of state, they might say, hey, if you have a dispute with us, you're gonna have to come to California, you're gonna have to come to New York to litigate this dispute. Frequently, you can change that language. If you're a Washington-based business, you might prefer to stay in Seattle to litigate your case instead of having to go to Los Angeles to litigate a case. Especially if you're creating intellectual property, such as a photographer or a videographer, or if you're hiring somebody to create intellectual property for you, it's important to know who's going to be owning that intellectual property at the end of the day. And these are just a handful of contract terms that are important that business owners often overlook when they're only thinking about the money that's being exchanged and the services that are being provided. A key thing I always tell clients is every contract is negotiable. No matter the difference in power or negotiating ability between the parties, I've never seen a party just say, we refuse to negotiate, we're walking out on this contract. There's all kinds of terms that can be negotiated for the contract, and it really depends on the contract and the specific needs of each business and what they're worried about. Sometimes contracts really are, the negotiation is just about price, or are we paying annually, or are we paying monthly, are we paying bi-monthly? But that's really kind of the minority of terms that get negotiated in contracts. More often it comes down to, how are we going to resolve disputes? Do we have to go to mediation? Do we have to go to court? Do we have to go to arbitration? Where are we going to decide these disputes? Who's shouldering the liability if somebody gets injured or something goes wrong in the project? If you have any questions about why contract review is important, please give us a call at View Ridge Law, and we'd love to help you out.